One other last thing that will be discussed. Over the last nearly 2 years, year and a half, almost half of all the examiners at the Patent and Trademark Office that do PTAB, those judges, have been dismissed or allowed to leave. As a result, what we're seeing is a systematic disabling of a process that was outside of Article 3 that often cleared up discrepancy about whether a portion of a patent was valid or not. There will be questions before all 4 of our witnesses, at least by the chair, as to whether or not that works.
Is America's patent system protecting innovation or protecting profits? In a heated congressional hearing, lawmakers are taking aim at pharmaceutical patent practices that critics say keep drug prices high and delay generic competition. From so-called patent thickets to questions about biosimilars, innovation, and consumer costs, this debate could shape the future of medicine in America. Are drug companies defending groundbreaking research or exploiting loopholes to extend monopolies? Stay tuned as lawmakers and industry experts clash over one of the most controversial issues in healthcare today.
The subcommittee will come to order. Without objection, the chair is authorized to declare recess at any time. We welcome everyone here today for a hearing on intellectual property as it relates to pharmaceutical and biotechnology products, biosimilars and the like. Without objection, Mr. Onder, who's not currently here, will be permitted to participate in today's hearing for purposes of questioning the witnesses if a member yields him such time as they may have. I now recognize myself for a brief opening statement. Well, it's never brief, but for an opening statement. For decades, the United States has led the world both in original innovations and in generic development. The FDA has ensured that we have products that are both safe and have efficacy. We are proud of that, but like anything else, pride in the past does not equal competitiveness for the future. Time and cost has dramatically increased for bringing products to market. In addition to that, patterns based on existing laws related to patents have caused behavior that will be looked at here today. The term thickets may be used more than once, but in fact, what we're really talking about is the same invention stated many, many ways. I take personal pride in the fact that when I invented something, I thought about how I could state it differently so that if a competitor wanted to produce a similar product, I had already determined and said in my original patent filing multiple ways the product could be. That's different than preferred embodiment, but in fact, the two can go hand in hand. Nothing here today is likely to cause us to change the fact that an inventor has the ability to state multiple ways to make a fine product. That exists in electronics, it exists in the pharmaceutical industry. We encourage that because the more disclosures of the more ways to make a product, the more you are enabling future inventors to see how it can be done. The problem we will be looking at with our witnesses, and I might note that our witnesses are deliberately evenly balanced by people who will speak perhaps with some bias toward the patent holder, pharma, big names, and the other two will speak mostly about the impediments to bringing biosimilars and generics to market. We do so because we have an obligation. The obligation under the Constitution is to promote useful development. Promote meaning it is not a right, but in fact an inducement by the government. And we need to balance that inducement to maximize new innovation and in fact benefit the consumer. The consumer clearly does pay more for a product during its first 20 years than it pays when biosimilars and generics become available. However, that is a long-standing part of our technology and one that we accept. Under the Hatch-Waxman Act, which we have had for 4 decades, we have a process for the transfer. And that, too, is a balancing act that this committee will likely not open Pandora's box on. And we do so because, in fact, our problems in many cases are outside of this committee's jurisdiction. The slowness and the great cost at the FDA is beyond our scope. But there are some things that we can do. One of them that will be proposed is the real question of whether pharma should have the same prohibition on make, use, or sell, rather than a broader exemption for export outside the United States to places in which the patent may not have validity. This concept doesn't always work, but as someone who believes in onshoring products, in investing in America, in getting more products, including critical medicines made in America, we have an obligation to ask that question. That's a major change in the law that will be discussed today. However, one other last thing that will be discussed. Over the last nearly 2 years, year and a half, almost half of all the examiners at the Patent and Trademark Office that do PTAB, those judges, have been dismissed or allowed to leave. As a result, what we're seeing is a systematic disabling of a process that was outside of Article 3 that often cleared up discrepancy about whether a portion of a patent was valid or not. There will be questions before all 4 of our witnesses, at least by the chair, as to whether or not that works to the detriment of clear and good patents. If there needs to be improvements in the PTAB process, this committee stands ready to offer legislation. But the idea that the Leahy legislation enacted more than a decade ago will simply be cast aside by one administration or not, in fact, thank you. I'm getting a SCOTUS update from today. I apologize. We'll deal with that in a minute. The fact is that we're going to discuss all of that, and we're going to ask our very knowledgeable witnesses to opine on it. The subcommittee's jurisdiction, though, is in fact limited to patents. It does not include the FDA, and so in spite of the fact that you may hear complaints about both the FDA and middlemen insurance reimbursement, please understand this is not something we can deal with today, and we would encourage all of our witnesses and members of the committee to concentrate to the greatest extent possible on that which is in the committee's jurisdiction, because it is broad and significant. With that, I take pleasure in introducing the ranking member of the subcommittee for his opening statement.
The battle over pharmaceutical patents is far from over. As Congress weighs potential reforms, the stakes couldn't be higher for innovators, generic manufacturers, and millions of patients who rely on affordable medications. What do you think? Should patent protections be strengthened to encourage innovation, or reformed to speed up access to lower-cost drugs? Share your thoughts in the comments below. If you enjoyed this breakdown of today's hearing, don't forget to like, subscribe, and turn on notifications for more coverage of the biggest debates shaping America's future.